Welcome to the Foreign Comparative Law webinar, where we will review the reports and products published this year. So, to start, the Law Library of Congress publishes content produced by foreign law specialists in three separate ways. First, our foreign law specialists create multinational reports on foreign comparative and international legal issues. These reports are written at the request of Library of Congress users. Additionally, our foreign specialists cover worldwide legal news and developments, which are published in our Global Legal Monitor, which we call GLM. And lastly, the Law Library has a blog called In Custodia Legis, which covers current legal trends and developments, as well as enhancements to congress.gov and collection issues at the Law Library of Congress and legal history of a wide range of legal jurisdictions.
So just to give you an overview of the GLM, the Global Legal Monitor articles provide a glimpse of global legal developments around the world. We strive to publish articles that are of interest to our readers and describes events that have happened within the past 30 days prior to being published. The Global Legal Monitor published 301 articles in fiscal year 2024. So to give you a few more numbers about the GLM for this year, in calendar year 2024, the highest number of page views occurred in January with 87,000, and the lowest was in July with just over 50,000 page views. There were a couple very high performing posts. In particular, the top viewed Global Legal Monitor articles involved regulations related to marriage and divorce in the Philippines. The most viewed article discussed same-sex marriage in the Philippines. That one got about 38,000 views. And the second most viewed article discussed the approval of a divorce bill by a committee in the Philippines House of Representatives. That one got 15,000 views. Among visitors to the Global Legal Monitor, 79% arrived via search engines, and the majority of readers are from the United States, as well as many countries around the world.
Wonderful. And the Law Library also, as we mentioned earlier, has a blog called In Custodia Legis, which covers current legal trends and developments. In Custodia Legis comes from the Latin in custody of the law and this acknowledges the role of the Law Library as the custodian of legislation both of the nation and the world. This blog provides a great variety of topics with a unique insight into a variety of laws and issues that affect the largest law library in the world. In Custodia Legis has a large number of readers each month with a total of over 882,000 page views through October of this year. Also, 74% of visitors to In Custodia Legis have arrived thereafter using a search engine, and almost 20% are repeat users that arrive through either bookmarking or typing the URL out. And we appreciate the repeat users. The highest number of monthly page views of this blog occurred in April when the blog received 101,000 views. The lowest number of views for this blog was 58,000, which was in June. And the most viewed blog post was the August 2023 post called What's in a Name? The 4 US states that are technically commonwealths, which had 46,000 views. And 91% of views for this post were from users who found it through search engines. The second most viewed blog post from In Custodia Legis was called Frequent Reference Questions. How many federal laws are there? From 2013, which had 16,000 views, and 51% of views were from users that got there through search engines, and 38% were from USA.gov, and which is quite a lot. And now for the following, we wanted to give you a little bit of ideas how we've done these blog posts and just give you some examples about them.
Yeah. So one blog post we'd like to highlight as being really interesting is titled When Loans Become Cheesy, Parmigiano Reggiano as Collateral. This was written by Heather Casey, an editor here at the Law Library of Congress. So this post explores the fascinating case of innovative banking from Italy's Emilia-Romagna region. The regional bank, Credito Emiliano, known as Credem, has been accepting an unusual form of collateral, since 1953, wheels of Parmigiano Reggiano cheese. It's important to understand that Parmigiano Reggiano is no ordinary cheese. It has a protected designation of origin, meaning it can only be produced in 5 specific Italian provinces. The production process is strictly regulated and has remained largely unchanged for 8 centuries. Credem's innovative approach helps local dairy farmers maximize their profits. Wheel of Parmigiano Reggiano can sell for $900 to up to $2,500 for each wheel, and the cheese becomes more valuable as it ages. However, farmers often sell younger wheels for quick cash, resulting in long-term revenue loss. Credem, the bank, offers loans of up to 70 to 80% of the cheese's value, allowing farmers to get immediate cash while the cheese continues to age and increase in value. The bank takes this arrangement seriously, storing the cheese wheels in climate-controlled vaults inspected by Parmigiano Reggiano experts for the duration of the loan. Interestingly, um, this post highlights the fact that this isn't the only example of unusual loan collateral. Historically, U.S. banks accepted whiskey before it was prohibited, and more recently, a Hong Kong bank accepted designer bags as collateral. A Spanish bank even proposed using soccer players Cristiano Ronaldo and Kaká as collateral for a loan from the European Central Bank.
Another interesting post in Custodial Edges is a blog post called Witchcraft and Haunted Case of Torture in Jus de Damhouders, Practice Rerum Criminalium. This blog post was written by Nathan Dorn, the Law Library's rare book curator, and it sparks the question on how much did the personal experiences of legal experts in Europe during the 15th to 18th century influence the practice of criminal justice. Nathan here concentrates on Jus de Damhuder, a lawyer from the 16th century who authored a relevant handbook on criminal law known as Praxis Rerum Criminalium, which means criminal matter practice. This handbook was very influential during that time in Europe, and the most interesting part of the book is a chapter on torture. This chapter states that individuals who practice magic may use magical means to avoid pain when being tortured, preventing the accused to confess their crimes, thus escaping from punishment. Damhuder states in his text that to avoid this, investigators should shave the entire body of the accused of witchcraft to expose any talisman or charms they may be hiding in their bodies. According to a book that was called Pratique judiciaire des causes criminelles, published in 1564, Damhuder was convinced that this process was required for investigators due to a personal experience he had between 1537 and 1550. The story Damhuder provides is of a woman who was accused of witchcraft for miraculously curing the injured and ill. During the first 2 rounds of interrogation for this woman, in which she was tortured, of course, she did not confess. However, on the third session, the investigators decided that they should shave all her body hair. Thereafter, they discovered a very small parchment in her body that had strange writing and a symbol of the cross. And once this parchment was removed from her body, during that third session of torture, soon after, she confessed that she relied on the devil's help to perform her cures. And that's the reason why thereafter in his handbook, he writes that investigators needed to do this during interrogation. And this blog post, as you can see with both of these blog posts, the law library staff involve a broad range of topics and jurisdictions, and we invite you to look at the law library's website to read other interesting blog posts that we have written.
Lovely. So this brings us to the Law Library of Congress reports. So the Law Library of Congress produces reports for the users. These can be for a single jurisdiction or multinational reports. When the Law Library receives a multinational request, each foreign law specialist produces a report on their assigned jurisdiction. After these reports are compiled into one multinational report, which includes a comparative summary on the subject matter, this report is then we add reference tables, lists of primary sources, maps, graphs, and other visual components. Each year, the Law Library creates between 350 and 400 in-depth research reports and provides answers to tens of thousands of questions on US and foreign law. Just recently, the Law Library digitized the collection of its historic reports written since the 1940s. Over 4,000 old reports were published on our website, law.gov. These reports are an interesting resource on the history of legal development in individual countries during the last century. We recommend you look at these whenever you have free time. We're sure that you'll enjoy them. While older reports only reference legislation and do not include policy or much contextual information, currently, all of our reports provide the context of the legal subject matter being researched. As an effort to provide sufficient background information and introduce relevant sources from our collection and online. The reports published by the Law Library this year cover a wide range of legal topics, such as the regulation of robocalls and robotexts, payments to former officials from foreign governments, book and media censorship, climate change and historic preservation, assisted dying, legal treatment of embryos created through IVF, biosecurity, and innovative technology. These reports are related to pressing legal issues in the United States and across the world and are often cited by media outlets. We would like to share with you some highlights of several reports we've published this fiscal year that cover current legal issues. All the reports we will mention have been prepared by staff of the Global Legal Research Directorate of the Law Library of Congress. So the first report we'd like to talk about is titled Offshore Processing of Asylum Seekers. It is a report from the Law Library of Congress, and it is a good example of a single jurisdiction report. So it's based mainly on the analysis of Australian government documents. This report examines Australia's offshore processing of asylum seekers, a policy that was introduced in 2001. So let me highlight a few key points of the policy. First off, the policy was initially introduced in 2001 as the Pacific Solution. It was dismantled in 2008 and then reintroduced in 2012. Australia signed agreements with Nauru and Papua New Guinea to establish processing centers for asylum seekers arriving by boat. Secondly, in 2013, the government launched Operation Sovereign Borders, a military-led initiative to turn back boats carrying asylum seekers. This policy, combined with the offshore processing, aimed to deter people from attempting dangerous sea journeys to Australia. Third, the report analyzes costs associated with the policy, averaging at least 1 billion Australian dollars per year. That's roughly 659 million US dollars. It also notes humanitarian concerns expressed in Australian legal literature, addressing 18 deaths occurring offshore or following medical evacuations since 2012. Fourth, the report represents the position of the Australian government, which maintains that the policy is necessary to deter asylum seekers from using dangerous means to reach Australia. They note that it has been nearly a decade since a death occurred during a boat journey. Lastly, the report describes views concerning the policy's effectiveness and reviews of the impact this policy had on host communities in Nauru and Papua New Guinea.
Another report that the Law Library has worked on is Spain Civic Space Legal Framework. This is a comprehensive report on Spain's legal framework related to civic space, and we would like to highlight some of the key points of this report. First, in Spain, anti-discrimination and equality, access to information, freedom of thought, the rights to peaceful, unarmed assembly, freedom of expression, privacy, freedom of the press, association, and civic participation are all enshrined in its constitution. Secondly, some of these guarantees have been further regulated by the law. For example, in 2022, Spain enacted a law on open internet. This was transposed inter alia with an EU directive that established the European Electronic Communication Code and implemented that reform of the telecommunications regulatory framework. In 2018, Spain enacted Organic Law Number 3 on the protection of personal data and the guarantee of digital rights to adapt the Spanish legal system to a EU regulation of 2016, number 679 of the European Parliament and of the Council of April 27 of 2016, which was called the General Data Protection Regulation. Thirdly, in regards to the creation of civil societies that is governed by the Civil Code and the Commercial Code in Spain, we looked at public utilities are actually regulated not by the Civil Code and the Commercial Code, but by an organic law, which is the Organic Law Number 1 of March 22nd of 2002, and the Royal Decree 1740 of December 19 of 2003, which regulates the procedures for declaring the public utility of associations. Spain has enacted several legislations to fight terrorism, prevent terrorist financing activities and money laundering, and provide rules for the recognition and compensation of victims of terrorism.
All right, we're now moving on to a multi-country report. This one's titled Legal Treatment of Embryos Created Through IVF. So this report surveyed the laws in select jurisdictions regarding embryos created through methods like in vitro fertilization, IVF. The countries surveyed were Australia, New Zealand, the United Kingdom, and 6 European countries, France, Germany, Italy, Poland, Portugal, and Sweden. The individual countries surveyed examined whether there is a legal limit on the number of embryos that can be created or transferred in a treatment cycle, and the actions that can be taken with respect to the embryos created. This included pre-implantation genetic testing, sex selection for non-medical purposes, cryopreservation and storage, donation, disposal or destruction, and allowing the embryos to be used for research purposes. Among the surveyed nations, Italy, Germany, and Poland stand out with the most restrictive policies. These countries generally limit or discourage the creation of multiple excess embryos and have strict rules regarding embryo donation and research. The report also focused on storage time limits for embryos preserved for the purpose of possible use in subsequent treatment cycles. The legal specialists reported that in almost all the countries that have a legal limit on storage duration, extensions may be granted by the relevant authorities. In some jurisdictions, such as the United Kingdom and Sweden, there are separate time limits when the storage of embryos is for the purpose of using them for research. In Italy and Germany, the ability to donate embryos to another person or couple is prohibited or highly restricted. In Poland, donating embryos to another person or couple is required when the storage time limit is reached. Italy, Germany, and Poland do not permit disposal of and research involving excess embryos. All the other jurisdictions surveyed allowed for excess embryos to be discarded, and disposal is required in several jurisdictions when the storage limits have been reached. This includes one Australian state, France, New Zealand, Portugal, Sweden, and the United Kingdom. Aspects of the law in Germany are currently under review by a commission established by the government. The law in Italy is complex, and there's uncertainty regarding some aspects, with certain restrictions having been declared unconstitutional by the Constitutional Court. So that'll be something interesting to follow up with in the next few years. All right, now moving on to biosafety and biosecurity definitions in G20 countries. So this report examined 19 jurisdictions, all part of the G20 nations. The countries surveyed include Argentina, Australia, Brazil, Canada, China, France, Germany, India, Indonesia, Italy, Japan, Mexico, Russia, Saudi Arabia, South Africa, South Korea, Turkey, the United Kingdom, and the United States. This research provides valuable insight into the global landscape of biosafety and biosecurity regulations from these jurisdictions. It discusses the definitions of biosafety, biosecurity, and related terms within the legislation of these jurisdictions. The foreign specialists that worked on this report provided regulations, guidelines, and secondary sources that discuss this topic in each jurisdiction surveyed. Some key findings of the report are jurisdictions with specific statutory or regulatory definitions, such as Australia, Brazil, France, Russia, and Turkey, have distinct legal definitions for biosafety and biosecurity. Jurisdictions with general statutory or regulatory definitions, such as Argentina, China, Italy, and Mexico, these countries define biosecurity broadly and do not include a corresponding definition for biosafety. Jurisdictions with definitions in government guidelines, such as Canada, Germany, India, South Africa, and the UK, these nations omit specific definitions for biosafety and biosecurity, but these terms are described in government strategy statements, research guidelines, and other manuals. For example, the United Kingdom published a security strategy discussing biosecurity issues, which included a broad definition for biological security. We found that jurisdictions such as Indonesia, Japan, Saudi Arabia, and South Korea have enacted laws addressing biosecurity topics, such as laboratory safety protocols, food and agricultural safety laws, and regulations to prevent the spread of communicable and infectious diseases, among other subjects, but do not have specific definitions for biosecurity or biosafety. This takes us to our report on the regulation of assisted dying. This report examined the regulation of assisted dying in 6 European countries, namely Belgium, Luxembourg, the Netherlands, Portugal, Spain, and Switzerland. Overall, the report highlights that while these countries have legalized assisted dying, they've done so with broad criteria rather than focusing on specific conditions, emphasizing individual assessment of suffering and incurability as criterion to qualify for assisted dying. First, all surveyed countries have legalized some form of assisted dying, but with varying approaches. Belgium, Luxembourg, and the Netherlands have the most established laws, dating back to the early 2000s. Portugal and Spain only recently legalized the practice in 2021 and 2023, respectively. Switzerland, interestingly, doesn't have a specific law, but allows assisted suicide under certain conditions within its existing legal framework. Now, while the specifics vary, all countries require the patient to be experiencing unbearable suffering from a serious and incurable condition. However, the interpretation of these terms can differ. For example, Belgium and Luxembourg explicitly include both physical and psychological suffering, while others focus more on physical conditions. Third, most countries have put in place stringent procedural safeguards. These typically include multiple doctor consultations, waiting periods, and review processes. Belgium and Luxembourg have also established special commissions to oversee and evaluate euthanasia cases. Fourth, an interesting development is the extension of euthanasia rights to minors in some countries. Belgium, for example, amended its law in 2014 to allow euthanasia for minors with parental consent and psychiatric evaluation. Lastly, it's worth noting that none of these countries cited specific diseases as rationales for passing their laws. The focus has been more on the nature and degree of suffering rather than on particular conditions. For instance, while diseases like Parkinson's or Alzheimer's have been mentioned in some discussions, they're typically used as examples rather than being singled out in the legislation itself. In Belgium, muscular diseases and physical handicaps were mentioned as potentially meeting the severity of condition criterion to qualify for assisted dying. So in the next slide, right here, you'll see wonderful graphs that were created by our visual information specialist, Bailey DeSimone. And so here you can see the nuance between the jurisdictions permitting euthanasia and those that just permit assisted suicide. There is, of course, some overlap. And on the bottom is the interesting figure on a jurisdiction with assisted dying procedures available to minors.
Okay, now furthermore, the Law Library has also written a report on textile waste bans in selected countries. This report surveys 33 selected jurisdictions regarding bans or restrictions on importing textile waste or secondhand clothing. Some of the results that came from that this report posted was first, countries such as Algeria, Bolivia, China, Ecuador, Paraguay, Indonesia, Sudan, Vietnam, and the Philippines are countries that have a total ban on used clothing. Secondly, some countries do permit the import of used clothing in specific cases. For example, in Peru, used clothing is prohibited for commercial purposes, but is allowed in cases of donations. In Argentina, they had a ban between 1991 and 2022 that excluded imports of donations. Another example is Brazil. This country only allows imports of used clothing received as donations, and only if the importer is a duly certified social assistance charitable entity. And in Kenya, we see that bans have specific types of used clothing, including certain nightwear, hospital wear, and undergarments, as well as used bath towels. In Bangladesh, restrictions of imports are based on specified types and quantities of worn clothing. And Tanzania only bans the importation of used undergarments. Costa Rica's importation ban only extends to used footwear and intimate clothing. And in India, for example, used clothing is restricted and requires a government license for it to be imported. Additionally, it can only be imported in a certain special economic zone. We also found in this report that Nicaragua and Antigua and Barbuda allow importation, but they require sanitation or certification of fumigation. Similarly, in Chile, they also require a sanitation certification, and they additionally impose a labeling requirement. In Hong Kong, they allow importation, but only with a permit issued by the Waste Disposal Authority, unless the waste is uncontaminated and is imported for the purpose of reprocessing, recycling, or reusing, or the reuse of the waste. And finally, one of um, one of the key points that the report specifies is that the reasons for ban include lowering environmental pollution, health and sanitary grounds, and protecting domestic producers and the economy. And it also highlights that Burundi, Colombia, El Salvador, Malaysia, Rwanda, Saudi Arabia, St. Kitts and Nevis, and Uganda do not have bans or restrictions on the import of secondhand clothing or textile waste. However, some of these jurisdictions, such as Colombia, Burundi, and Rwanda, do impose very increased custom tariffs.
That one was interesting to see what was being called a ban, but was actually just a steep tariff. Worth a read. All right, so the next slide is going to be about the report on regulation of robocalls and robotexts. This comprehensive report examined the regulation of robocalls and robotexts across 17 jurisdictions worldwide, including the European Union and the United Kingdom. So first off, it's important to note the diversity in regulatory approaches in this context. While some countries have specific anti-spam legislation, others address these issues through broader telecommunications, data protections, or consumer protection laws. For instance, Australia, Canada, and Singapore have implemented specific anti-spam legislation. In contrast, countries like France and Sweden address these issues through broader telecommunications and data protection laws. Now, despite this variety, we see some common features emerging. Many jurisdictions require explicit consent before sending marketing calls or messages. Do not call registries are also widespread, with 12 of the surveyed countries implementing such systems. For example, Singapore's do not call registry has been particularly effective, with a significant reduction in complaints over the past 5 years. There's also growing focus on combating caller ID spoofing and authenticating caller identities. The UK requires providers to ensure that caller IDs are connected to valid, callable phone numbers. We're seeing some interesting new trends as well. Countries like Australia, Ireland, and Singapore are exploring or implementing SMS sender ID registries to combat scams. Australia is piloting an SMS sender ID registry to protect against scams, while Ireland is considering a similar measure. This is interesting in comparison with the US, where there are emerging regulations around AI-generated calls, with the FCC proposing new disclosure requirements for such calls. And interestingly, some countries have stricter regulations than others. For instance, Russia prohibits commercial robocalls and robotexts sent automatically without human operator involvement, while other countries allow them with consent. However, the report highlights that international coordination remains limited. While there have been some efforts through organizations like the International Telecommunications Union, there's no comprehensive global platform for addressing these issues.
Wonderful. As we said, we've worked on diverse legal issues and topics, and we've also worked on climate change and historic preservation. Um, and this report covers legislation concerning climate change and preservation of historic and cultural heritage. The countries surveyed in this report were Brazil, Colombia, Finland, Great Britain, Ireland, Italy, Spain, and the United Arab Emirates. The report addressed three main points. First, is there legislation in these jurisdictions regarding reuse and retrofitting of historic buildings to reduce energy usage? Secondly, do these jurisdictions have regulations on the adaptation of historic buildings or historic districts in response to climate change? And lastly, do these countries have regulations that integrate indigenous or traditional knowledge or collaboration with indigenous communities in government actions to protect or adapt cultural or historic properties? And what we found, or what the report concluded, is that countries such as Brazil, Colombia, Finland, Spain, and the United Arab Emirates have legislation to protect historic buildings, but they don't have specific regulations to promote reuse and retrofit of these buildings, nor anything related to adaptation to climate change. In countries such as Great Britain, Ireland, and Italy, they allow to some extent to perform works to improve energy efficiency in historic buildings, but there cannot be substantial alterations to the historic buildings. For example, in Great Britain and Ireland, they require, or you require a permission for these works, and the construction may not affect the character of the historic building. In the case of Italy, they have a specific legislation on reuse, retrofitting historic buildings to reduce energy usage that requires the preservation of cultural historic meaning of the building. And in countries such as Colombia and Finland, the report stated that they have regulations that promote the collaboration with indigenous communities in government actions For example, in Colombia, the collaboration with indigenous communities derives from the constitutional right of prior consultation. In this case, prior consultation must be done when there is any kind of intervention within their territory. And in the case of Finland, Finland's regulation is more specific and establishes that the government must consult indigenous communities in the development of climate-related plans.
Thanks, Stefania. So the next report we're going to have a look at is titled Innovative Technology in Legislatures. So this report examined the adoption of innovative technologies, so particularly artificial intelligence, in legislatures around the world. So let me highlight some of the key findings for you. First, the adoption of information and communication technology, ICT, is widespread among parliaments globally. All surveyed jurisdictions have robust digital management systems and open data policies, making vast amount of information freely available to the public. For example, Canada's parliamentary website includes features like electronic petitions to enhance citizen engagement. Now, secondly, we're seeing a growing interest in AI applications for parliamentary functions. Brazil's Chamber of Deputies launched an AI tool in 2018 that organizes and presents diverse data on their website. Italy's Senate is using AI to streamline the amendment process, while Israel's parliament employs AI for speech-to-text transcription of plenary meetings. The COVID-19 pandemic significantly accelerated digital transformation in legislatures. As we've seen, many parliaments, including those in Brazil, Canada, and the UK, quickly adopted remote meeting and voting technologies to ensure continuity of operations. The report also noted that there's considerable variation in how countries are approaching AI regulation and implementation. For instance, Canada introduced a directive in 2019 to ensure ethical use of automated decision-making systems. And Spain has approved an AI regulatory sandbox for testing systems in a controlled environment, while the Ukraine is considering a similar approach. Lastly, several parliaments are running pilot programs to test AI tools. India and Israel are developing AI-based chatbots to assist members of parliament with research and reference requests. Ukraine is working on AI-supported tools to enhance data accessibility on its parliamentary website. Hmm. Oh, and as a funny anecdote, I know the French Supreme Court, the commercial court, is also thinking of using AI to speed up summarizing their decisions. So this overview underscored the rapid technological evolution in legislative bodies worldwide as they strive to balance innovation with transparency, efficiency, and citizen engagement.
That is a really interesting report to read. Furthermore, we have also written a report on regulation of payments to former officials in select countries. This report surveyed 46 jurisdictions and it examined whether the selected countries had enacted legislation, either establishing a prohibition for former officials from receiving payments from foreign governments for a period of time after leaving office, or that required disclosure of such payments in selected jurisdictions. This report did not include general provisions that regulate lobbying activities, which may apply to former officials. It also does not include illicit enrichment laws that enables recovery of assets not obtained from lawful sources, many of which also apply to former officials. And for these jurisdictions, we identified that Australia, Austria, Canada, China, Finland, Germany, Israel, Japan, Malta, Mexico, Nigeria, Norway, Russia, Slovakia, Sweden, and Taiwan have enacted one or both such types of laws. As you can see in the slide, we have two maps, which were created by our visual information specialist, Bailey DeSimone, specifically for this report to show our research findings. In these maps, we included countries that were surveyed, which did not locate either type of provision. And as you can see in the first map, shows whether each survey's jurisdiction has a prohibition on former officials receiving payments from foreign governments, while the second map shows whether each survey jurisdiction requires disclosure of such payments. As we can see on map 1, Austria, Canada, Finland, Germany, Israel, Malta, Mexico, Nigeria, Norway, Slovakia, Sweden, and Taiwan have a prohibition on former officials receiving payments from foreign governments. Map 2 shows that Australia, Finland, Germany, Israel, Japan, Norway, Russia, Slovakia, and Sweden has legislation that requires disclosure of such payments. And lastly, the report highlights that some countries do not specifically mention foreign governments. For example, Germany. In Germany's legislation, it provides that federal employees are prohibited from requesting, accepting a promise for rewards, presents, or other advantages for themselves or a third party in connection with their office even after they leave office, which is not a specific mention of foreign governments, but it's an inclusive provision.
Lovely. Another interesting report. Oh, do you mind going back for me? Just one.
Yes, sorry
We
about
do
that.
we do have one more for you. Uh, so this one is titled Book and Media Censorship in Selected Countries. So this report, as the name suggests, examined book and media censorship across 22 countries, providing insight into global approaches to freedom of expression. So let me just highlight the key findings for you. First, while most countries surveyed have constitutional or legislative protections for freedom of speech, many also have laws regulating matters such as obscenity and incitement. This highlights the global challenge of balancing free expression with other societal concerns. Many countries place special emphasis on protecting minors from harmful content. For example, Malawi criminalizes showing offensive material to children, with penalties of up to 7 years imprisonment. Trinidad and Tobago prohibits publications likely to corrupt children, especially those depicting violence or crime. The reasons for censorship vary widely. Some countries, like Israel, Russia, and Uzbekistan, focus on national security concerns. Others, such as China, Cuba, Egypt, and Vietnam, have laws against materials critical of the government. Russia has recently introduced laws restricting LGBT-related content and materials from foreign agents. Approaches to censorship differ significantly. While some countries impose strict bans, others, like France and the UK, have moved towards a case-by-case restriction. Sweden ended public censorship of movies in 2011, replacing it with age recommendations. Lastly, we're seeing some interesting trends. India recently replaced colonial-era censorship laws with new provisions in its criminal codes, and the UK is grappling with balancing human rights obligations against anti-terrorism laws and equality duties. So, as you can
Yeah.
see, the law
Yes.
library produces a wide variety of written products that cover a range of subjects. This includes our reports, written response to congressional requests, global legal monitor articles written to provide information about legal developments from around the world, and blog posts for increased audiologists that provide a unique insight by our authors into a variety of laws, as well as issues impacting the law library. We hope this presentation has been helpful and introduced you to some resources and subjects that you might not have been aware of. And we hope it encouraged you to delve further into the information we provide online. We'd like to thank everybody for attending. We encourage you to look at the Law Library's resources since they offer a variety of legal information. And we hope you all have a wonderful day.
Yes, and please visit the link on the slide to see the next foreign and comparative law webinars. And if you
Amazing.
have any additional questions, we welcome you to go to Ask a Librarian, which you can see the link on the slide, and we would be very happy to answer them.
See, we're just waiting to see if there's any questions that we haven't answered. I don't see
Remember,
anything. We're just going to hang around and see if anybody has any questions. And if not, have a lovely day. Thank you so much for attending.
Yes, we hope you all have an excellent day and hope to see you next on our next webinar. Well, since there are no questions in the chat box, we would like to finalize today's webinar. And again, welcome to all the attendees today for watching our Foreign and Comparative Law webinar for this year. And we hope to see you on the following webinars. Have a wonderful day to all of you.